Hi, my name is Suzanne Hale Robinson, and I'm a partner at Hale Robinson & Robinson. I'm here today to discuss the implications of a child being exposed to COVID and how that affects parties' parenting time with that child. In several of my cases, there's been a child who's been exposed to COVID. At that point, the parents call me and ask, what should I do? And my answer varies. Typically, my first piece of advice is to follow the recommendations and guidance of the CDC. The CDC has recommended that when someone is exposed to COVID, they quarantine for 14 days. If the child has been exposed to COVID and is currently in one parent's care, several parents that I've had will just keep that child in their care and not allow parenting time to the other parent. This can only happen if both parties agree that that's the appropriate course of action. You get into trouble when you're trying to withhold parenting time because of COVID exposure and the other party does not agree. Technically, I cannot advise any clients, and people are not supposed to violate court orders. So absent an order from the court saying that parenting time ought to change based on the child's exposure to COVID, the parties are required to still follow their parenting plan. My advice is to attempt to work with the other parent to get an agreement to allow the child to quarantine with the parent whom he or she was with when the exposure took place. If you're unable to do this and you cannot come to an agreement, my advice is always to follow the court orders or call an attorney and see if we can get an order in place to get that modified to protect your family. If you have questions about this or want to reach out to the court to modify parenting time because of COVID exposure, reach out to us at 913-709-1788, or you can book an appointment with one of our attorneys at www.hrrlawyers.com. Thanks.